Hello, you have Ted Corliss with the Corliss Law Group. Welcome. Today's media production relates to the upcoming anniversary of the Champlain Tower South collapse that occurred in the Surfside community located within North Miami Beach, Florida. On June 24, 2021, a 12-story building collapsed, killing 98 people. 4 people were rescued from the rubble, and one of those individuals ultimately succumbed to their injuries. The problems associated with this building are the purpose of this media, primarily to address the future handling of maintenance and structural issues associated with condominium developments, large buildings like this, so that we can learn from the mistakes of the past and potentially save lives in the future. Now, in the Surfside situation, there were problems reported and even contained within multiple reports issued in 2018, 3 years before the collapse. During that 3-year time span, the owners of that particular building, likely the board of directors of that building, obtained an estimate and structural repair plan valued north of $15 million. And that particular estimate occurred in April of 2021, a short 2 months prior to the collapse that occurred in June of 2021. Now, this particular collapse is important to be placed in context, first and foremost because the number of people that were injured or died as a result of the collapse. This particular event ranks third as the third deadliest structural failure in American history. The other important thing to do is to put it in context that these kinds of mass casualty events associated with structural failures are exceedingly rare. In fact, if you look at the 2 structural failures that occurred before and more people were killed, the first and highest ranking number of fatalities comes from an event that occurred at the Pemberton Mill property, which was an industrial complex that collapsed, killing 145 people. But the date on that is relevant in that it occurred in 1860, prior to the American Civil War. The other collapse that I believe would be relevant to discuss here would be the collapse that occurred in Kansas City, Missouri in 1981 at the Hyatt Regency, where a walkway collapsed, killing 114 people while also injuring 216. To address some of these issues for the value of those of you out there who are property managers, those of you who own condos, and especially those individuals that serve on the boards of directors of these individual properties, we're going to be offering you a conversation that I had recently with a condominium lawyer by the name of Dan Greenberg. Let's jump right in. As we address the anniversary of the Surfside collapse, it is my pleasure today to bring in as a guest of our podcast, Dan Greenberg. Mr. Greenberg has just on the edge of 20 years experience in the condominium world. Many of his clients are associations who are very interested in the things that are going on in the state of Florida as a result of the Surfside collapse. Today, we're going to talk about some of the bills that almost passed in the state of Florida addressing some of these issues. This podcast is especially important to those listeners out there who may be members of boards of directors for these associations, wanting to know what responsibilities they may have to address the same or similar circumstances that occurred at Surfside. You may not know the building collapsed as a result of serious structural problems that had been discovered in the years prior to the collapse. So the question becomes, you're on a board. What are our responsibilities to our unit owners? What are our liabilities for the choices that we make? And Mr. Greenberg is here today to help us unpack some of those issues. Hello, Dan.
Hello, Ted. Thank you for having me.
My pleasure. My pleasure. What is your impression of the last year as to how Surfside's terrible incident has affected your clients in the state of Florida?
Yeah, my clients fortunately took lessons out of Surfside in the respect that they paid extra attention over the last year to the health of their own building. And I think that was really a statewide response. What I've experienced over the last year are a lot of questions coming from the board about what they should be doing regarding the health of their building, because this is simply not a topic that had come up with them before. And unfortunately, while this recent legislation tried to address that issue, to mandate some of those procedures and to help boards understand what they should be thinking about, short of that legislation, what I found is that most of my boards had never even considered the possibility that their building may be in such poor health that they would suffer a similar fate to Surfside. So I think it opened a lot of eyes to what may be lurking beneath the exterior of the buildings. And I'm fortunate and I'm glad that my boards are thinking about these topics, but it came at a tremendous cost. So I'm extremely sad that we experienced this event, but I hope that we will come out of it stronger as a state, and that my boards will continue acting responsibly, and that hopefully our state legislature will, in the coming year, create a solution to help our boards confront this significant traumatic event.
Now, we'll go through some of the legislation that kind of made its way pretty far, didn't it? It made it pretty far through the process. They just didn't close the deal, I guess. And the question then becomes, if the state of Florida is not going to mandate milestone inspections, then should property owners in these condominiums be demanding that the properties be inspected for these purposes?
I think that demand has already begun. If it hasn't started at the board level, we've certainly experienced members within the community expressing these concerns to their boards and demanding action. And that action has come over the last year in the form of inspections. I know the engineers that we all work with have been extremely busy over the last year doing preventative type inspections, the type of inspections that were actually contemplated in the statutes we'll talk about in a minute. So I think the demand is there. I think the members are awake to this possibility, and no one is sweeping it under the rug, which is good. It's very heartening to me. It's what we do with it and making sure that we have a plan, because it's one thing to identify a problem, obviously. The issue that many of my clients have is one of limited resources.
Understand.
And so it's critical for them to obtain the guidance of good professionals in order to even formulate a game plan. How do we address this? And part of that issue comes in the fact that condos are an interesting creature. While they're corporations, they're run by laymen who very well may have zero background training that lends towards managing a high-rise condominium specifically.
Right.
And that's where we were all hopeful, I think, that the legislature would step in to help provide that guidance, but we fell a little short.
Right, right. We're using this expression. I'd like to take a moment for you to help me understand. We're talking about what is being referred to as a milestone inspection. You tell me a little bit more about what that would consist of.
Well, as proposed in the statutes, the numbers that were used essentially were a 30-year milestone inspection. And this is, by the way, within both statutes, the Senate and the House, both proposed statutes. They really addressed only 3-story condos or higher. Okay, now that's not to say that a 2-story condo can't experience issues, and that's a different topic, but this was really relating more to the high-rises, specifically in line with Surfside. So the 2 milestone inspections that were proposed related specifically to 3-story condos and were determined based on their location. So condos within 3 miles of a coastline would have had a 20-year milestone inspection with follow-ups every 7. Those condos located more than 3 miles from a coastline would have a 30-year milestone inspection followed by 7-year follow-up inspections. So and I'm not an engineer, so I don't feel particularly qualified to speak on that as to why 20 and 30 years are critical with respect to potential degradation of the building, but those were the numbers that the legislature were working with.
Now, when you talk about a 20-year inspection, are you talking about we're looking at the date of original construction?
Correct.
We're counting 20 or 30 years, and we're saying that the state of Florida was considering requiring a kind of a suite, if I can use that expression, of inspections that would take place addressing the structural members, because again, understanding the Champlain Tower South collapse, what we're calling the Surfside collapse. So the name of the community was Champlain Tower South, and it was in the Surfside community. It was in North Miami Beach, wasn't it?
Yeah, that's right.
Okay. And the issue here being that the building was developing significant or material in issues with the structural integrity of the building. And the belief is that if we mandate these inspections, we mitigate the possibility or reduce the possibility really of having another one of these events occur. It might make sense only to have 3 stories or higher because 2-story buildings don't tend to collapse. They certainly don't collapse and cause the death of almost 100 people. But that doesn't mean that a 2-story building wouldn't itself require something that may be beyond the scope of a particular lay member of a board. I mean, you know these people on these boards, they work really, really hard to make the right choices. It doesn't mean that we don't occasionally encounter people who have their own self-interests. But I always joke with the board members that I represent, make sure and pick up your W-2 on the way out, because you're paid so well to do this, which is zero. These people are volunteers and they get heat from other people. So I think one of the benefits of these milestone inspections is that because they're mandated, we're not going to have a bunch of fights and board meetings because they're just going to have to do what they have to do.
That's true. And the problem that I have with the milestone inspection dynamic is that it ignores what happens within that first 20 to 30 years, which I think is where most condominiums would be best served focusing their energies. It's wonderful that we get to a 30-year window. And yes, we can certainly catch a disaster before it happens by having that kind of milestone inspection. But as a general counsel for condos, my goal is to help them plan. My goal is to help them create efficient policies and procedures that will help avoid obviously catastrophic loss. But beyond that, it's helping them avoid unnecessary expenditures. And the way that we do that typically is by having better preventative maintenance up front and understanding the timeline of a building. And this is where we really rely on the engineers to help fill in a lot of the gaps. But there's a general timeline I think that most high-rise condominiums should be keeping in mind in terms of when things should happen. So we can say a milestone inspection in year 30, that's wonderful, but we simply cannot close our eyes to that 30-year period between turnover of a condominium from the developer and a milestone inspection. So I think it's going to be critical for boards to be even further educated, both by the attorneys and by the engineers or by the architects, as to what they should be doing within that 30-year period to mitigate their costs, number one, and obviously avoid a disaster.
Right. And so the idea here might be that the individuals listening to this podcast may say, I'm very curious and concerned about the condition of the condominium that I help manage, or I'm a unit owner and I believe that there are concerns about the condition of the structure where we are. And so how is it that let's go into the bills that didn't pass as a final law, but tell me how far they got through this whole process. Let's do this. I'm just a bill, Dan Greenberg style. Okay.
The intent was great. Okay. What was in these bills, I think, ultimately will be passed in some form, and I think ultimately will be helpful. The key distinctions between the Senate and the House bill really related more to the reserves that condos are required to maintain by statute. And just kind of a brief overview of that. So every condo is subject to the Condominium Act 718 Florida statutes. That statute contains reserve provisions that require condominiums to have certain statutory reserves. Those include painting, paving, and roofing, and this catch-all provision of anything with an expected, anticipated replacement cost in excess of $10,000. Now, depending on the condominium, this could be any number of things, whether it's the obvious things we think about, elevators, gates, a pool, irrigation, you name it. We can have any number of components that cost more than $10,000. And that really varies from condo to condo. The one thing that does not vary from condo to condo is the internal infrastructure of that building, which I think every engineer would agree will not last in perpetuity.
Right. Okay. It has a lifespan.
It has a lifespan.
Right.
Yeah. So the problem that I've seen in representing many hundreds of condos over the years is that no board that I am aware of is thinking about the internal components of their building. I believe they are taking for granted that the building was well constructed and will be there, if not at least for the lifetime that they are there, some indeterminate span of time. And the other factor, of course, is budgetary. I don't have a single client that I'm aware of that keeps an infrastructure reserve in excess of, say, $1 million or whatever it might take to actually go back into that building and replace failing components or catch them before they fail. But whether it's steel, whether it's concrete, these all have definitive timelines that they will exist in their current form sufficient to keep that building standing. It is not in perpetuity. So while the statute theoretically provides that every condo should be accounting for this an inevitable infrastructure project, whether it's your balconies or garage or otherwise, not a condo that I'm aware of is actually keeping a reserve in that huge dollar amount range. They're focusing on the things that they can actively see. And I call it an out of sight, out of mind problem. And it's nobody's fault in terms of at least the board, and I agree with you. We work with these boards who are volunteers and oftentimes retirees. They come from a broad range of careers and lifestyles and perspectives.
And resources. Right.
And without guidance or education as to what they must be accounting for, it's simply too easy for that to get forgotten or swept under the rug or just simply pushed off in some cases, which is what appears to have happened down in South Florida, because they were not unaware that there were building condition issues.
There was actually a report that they had in their possession, I believe, that indicated the significance of what was going on there.
Absolutely. And so what it all seems to be coming back around to was finances. Okay, and part of the reason why these bills currently did not pass was a failure to reconcile the Senate and the House bill with respect to reserve contributions, because while we have this obligation to, quote, fully fund reserve accounts, those mandatory reserve accounts, and what that means, by the way, is not that I need to have all the money in the bank today. If I've got $1 million roof, I don't need $1 million today. I need to be on track to collect $1 million for that roof by the end of the useful life of that component. So a fully funded condo budget means we've accounted for all of these structural components on our property. We've examined their current state. We've diagnosed the useful life. We've tried to come up with a replacement cost, and now we save each year in the budget through our monthly or annual assessments into each of these reserve buckets, so that hopefully at the end of the useful life of that component, we can pay the full bill to a vendor. We don't have to worry and scramble about raising funds. Now, the problem with that is the statute also has a backdoor. What it allows condos to do on an annual basis through a vote of the membership, not the board, is to waive the full funding of those reserves. So the board can, around budget time, send out a proxy vote to its members.
Usually around January is when they do a lot of these. It's the beginning of the year.
Typically, actually, it's in the fall.
In the fall,
so
okay.
Typically October,
it's for the
November,
following year.
For the following year,
Got it.
Correct. So in October, November of each year, they're going to determine the assessment amount for the January of the following year. So what many boards will do is send out a proxy question to their membership and say, will you give us permission to adopt a partially funded budget? They provide both budgets. Here's budget A with a fully funded budget. This is the dollar amount per month. Here's option B, which is a partially funded budget, which is going to be significantly less. So boards are not required to give their membership the option to waive full funding of the reserves. Every board has an absolute right to pass a budget that is sufficient to account for all of the financial needs of the association, both on the operating side and the reserve side. Boards, though, oftentimes will be responsive to their membership's desire to keep assessments down, or responsive to the financial limitations within that particular association.
Well, it's almost kind of a political pushback.
Absolutely.
They're gonna do as much as they can. I mean, I guess the difference is when you own a single family residence, I don't put money aside every year for the roof that I'm going to have to replace at some time in the future. I'm just going to live in my house as long as I can until I need a new roof, and then I'll go do the things that people do. They'll go get a second on their house. They'll use money from a 401k to make a capital improvement. But the reserve process is set up such that we find out our paving, for example, our parking lot looks okay, but probably in about 5 years, we're going to have to pay to get a new one. And the idea is to take the cost of that new pavement and divide by 5. And what I sense happened is that during the real estate crash, the end of 2008, 2009, the value of these properties just plummeted. Well, you may have bought a $375,000 condo that's now valued at $125,000. And now you're finding out we need new pavements. Now we haven't assessed for it, but we're going to start charging everyone a little bit every month so that when it ultimately comes to pavement time, we have savings, I guess. But the political difficulty of that too is that what I've seen is that people say, well, wait a minute, what if I move in 3 years? So you're telling me that I'm giving you money for capital improvements that I won't even have a benefit of. But then we come down to the reality of living in communities like these. And that is that you are now in a communal environment where you have to do things that don't necessarily benefit you.
Yeah, well, I would actually, I would make a counter argument there that these folks are currently taxing the system. They're benefiting from the existing capital improvement. So they are taxing the system that was put in 20 years ago. And they are creating the need for the system to be replaced 20 years from now. And so if we really look at it from that communal standpoint, I think every condo owner has to accept the fact that they are using the facilities, they are taxing the facilities, and they all have to be contributing. And if they are all contributing from day one, we are spreading that risk across generations of owners within that community, and no one is caught paying a disproportionate share when a component is necessary to be replaced. But the philosophy that you're describing is one that's all too common, which is that, hey, right now everything is fine. Let's keep our costs down. We'll let the next folks deal with this problem.
We're going to kick the
can.
We'll
kick the
can.
As I described it to you earlier, it's kind of like a Ponzi scheme, Ted. I mean, we're going to live in this building for as cheap as possible now, and we're gonna push the buck down the road, and someone's going to end up getting caught holding this bag, but it ain't going to be us, either because we're too old or we're planning to move back to Canada or whatever the case may be. It's short-sightedness, though. And one could argue, although the statute gives us the out, is that it truly is a breach, if not of the fiduciary duty of the board, because we can't say that because the statute allows, for all this. It's not that the boards are doing anything wrong. It's a breach of the communal concept. It really is. And so it's something that's difficult to deal with because we have different philosophies and a lot of diversity within these condos, both from that kind of philosophical perspective and also financial wherewithal. You very well may have buildings that consist of folks that have been there for 40 years who are very much on a fixed income and bought it back when it was very affordable. And this is what happened down in Surfside. And someone coming in today who's going to pay $1 million for that condo and comes from a completely different financial background, and yet they're neighbors. But if the folks that come in with resources are outnumbered and outvoted by the folks that are there with other financial concerns, this becomes a numbers game, and you cannot force place that your financial status on your neighbors, and so it becomes a continuous balance of how we take into consideration the actual needs of the building versus the actual needs and resources of our members. And this is left up to a volunteer board who are elected oftentimes in one-year cycles. And the problem is they're dealing with this on top of all the other day-to-day operations of the condominium. And it very well may be their board's term is essentially at its end before they can even get to and tackle a large project. Now what happens? A new board comes in. What's the project they're going to pick up first, Ted?
Right.
The $1 million reconstruction of the building and dealing with engineers, or repaving the parking lot and making sure they get new pool furniture and dealing with the lobby and updating the kitchen.
Or the guy who's smoking cigars on his patio, or as you said, this obsession with service animals that are not really service animals. They're emotional support animals, right, or whatever. Yeah. Every time I go to any kind of event where we're talking about condominiums, everybody brings up that damn emotional support animal. All right. So let's get back to the bills. So it passed in the Senate, correct?
Yeah.
Passed in the House, yes, but they were different.
Different versions of the bills.
And the big difference was this issue of whether or not the House wanted to say you can no longer waive reserves.
That's correct.
But let's talk about the effect that would have on a lot of people, because if you're telling me painting, paving, and roofing and anything that costs more than $10,000 or has a usable lifespan, what are we talking about? I mean, if you were in a particular condominium, do you have a sense of what kind of numbers we're talking about if you've waived reserves?
Well, it's tough to say because every condo is different and has different facilities, right? But and this is a great question for when we have the engineers on, as far as what the total cost is of a potential, reconstruction type project or a shoring up of the building or whatever goes into that. I'm not sure what the dollar amount is, but I assume it is significant. So when we're talking about, these condos that are already kind of putting out, we've had insurance prices go up tremendously this year. We've had materials prices go up this year. So even the roof that they have to do that we know they're going to do, they're experiencing significant increases there. So everybody has been pinched over the last couple of years with supply costs going up so much. So even the basics that no one's balking at, everyone knows we're going to do the roof. Everyone knows we're going to paint the building. Well, and everyone knows we're going to insure the building. Well, when the cost of those basic functions that we're already thinking of and willing to do has gone up so much, then our willingness, I think, to address these even more significant, more costly projects goes down. Most boards, I think, feel we don't want to be the board to tackle this one. We'll do the other stuff and we'll kind of tee it up for another board. And that's been the problem, is the kicking the can down the road. And back to this reserve issue. And while I don't have a dollar amount, it's significant because the difference between a partially funded or a completely non-funded reserve and a full funded reserve can be absolutely dramatic. I mean, we could see assessments double easily, if not more, easily.
Oh, yeah, because you're talking about some of these capital improvements could be in the hundreds of thousands of dollars, and there may only be 25 units.
Absolutely.
You could, when these taller buildings, the commercial construction costs more. Right now, if you happen to have a few thousand windows that you want to sell, I know a few thousand people that would want to buy them from you. But between supply side disruption, you take a look at the fires that occurred in Colorado last summer, where they destroyed 1,200 homes. The year before that, there were 4,000 acres burning in California that destroyed thousands of homes. All those homes that I've just described need new windows. They all need new roofs, and they can't get them. And then enter the pandemic, and now people are waiting years just to get the materials, and the money associated with that can be absolutely, very substantial.
It is, and it's daunting. It's a daunting concept to the average condominium board to think about a large-scale building reconstruction or rehabilitation project. Now, the problem is, they're going to be faced with it if they allow this to go so far and don't address it in a proactive manner. But, for them to deal with this today while they don't have what would be called an active issue is just something that I think ultimately becomes too daunting when there's not a clear path. There's no guidelines. There's no state assistance. There's no one who is dedicated to helping these condos even navigate this process. It has to come from within because we aren't being told, what to do. I believe we still only have 2 counties in this state that actually require currently these milestone inspections. And Pinellas and Hillsborough and Pasco are not 3 of them, and that's where my primary practice area is.
And there are just, would you have any idea how many associations we're talking about?
Yeah, thanks. So I looked up these numbers prior to. So this is mind blowing. So apparently in the state of Florida, we've got about 2 million people living in about 900,000 condo units that are over 30 years old right now. Okay.
Wow.
But we've got 105,000 of those units are more than 50 years old. And we've got another 132,000 condo units between 20 and 30 years old. This is an endemic issue.
Wow. Well, and you and I both as lawyers know that's a big invitation to a whole bunch of litigation. And the litigation would be between unit owners and their associations. There would be litigation between the associations and different vendors that they use. And I mean, I recall recently being at a condominium, and it was a relatively new development. And I said, when was the last time the building was painted? And one of the board members kind of looked at me a little confused and said, what do you mean? It was painted when it was built 17 years ago. And again, I'm originally from the Midwest. We would paint houses up there every 10 years. But in the state of Florida, you paint your buildings a hell of a lot sooner than that. And if you're on the water, everything changes. I mean, you have to wash your windows 4 or 5 times a year because if the salt collects on the windows and then the water hits it again, it gets to the bottom of the window and just chews through all of that. And so those lay board members are bringing their knowledge of construction and home maintenance from another community it's wildly different than what goes on here between the moisture and the heat.
That's absolutely right. And so, this is where it kind of get into a real struggle with what the board's fiduciary duty means, because there's so much that goes into it. Okay, and oftentimes we're talking about 5 human beings who are determining the fate of hundreds of others, right? And so not only, again, are they dealing with this kind of day-to-day, which is where 90% of their time gets eaten up. It's the ticky-tack stuff like, the parking and the pool and the pets and everything else. I know because I deal with it on a daily basis. The last thing that these boards have the time and inclination to do are take on massive projects that involve necessarily expert opinions, because everything comes with a dollar sign attached. And getting back to the 2 bills and why they ultimately couldn't reconcile, the House wouldn't budge on its demand that we end the waiver of full funding reserves. They said we have to have these high-rise condominiums, at least at a minimum, fully funding their reserves from day one. We have to avoid this. The way we avoid this is through money. And I understand the logic there, because we can tie a lot of the Surfside issues back to budgeting. It's not that they weren't aware of the issues. They had written reports. It's not that these weren't visible, evident issues. They were. It all comes down to money. And so the House, I think, is, their heart was in the right place in saying, hey, why don't we take the money element out of it? Why don't we just cause these condos to do the responsible thing from day one and start saving? Because if we do that from day one, I mean, this is just common logic. It's going to be much more likely that we are going to be in good financial health if we start thinking about it on day one. And same as your retirement, you want to start theoretically in year 1, not year 20.
Okay, so let me ask you straight out. Which bill did you think made more sense?
Yeah. I mean, if it was up to me, I would love to see the waiving of full funding go away. I mean, my own personal experience as a former condo owner, it's so convenient for a board to just wait. We'll just the second week of every January, we would meet and they would have a hearing, or not a hearing, they would have a meeting where they would say, let's waive
funding of reserves, and everybody's like, woo, yay,
Yeah,
I don't have to pay anything this year. And then, there are significant problems that develop over time, and the board members stay on for a while, and then when the problems become too much to bear, they step off the board.
Yeah.
And then another person, very well-intentioned, comes on the board and is now trying to understand how we can right the ship a little bit. But I also acknowledge that it's one thing to start on day one at the new developer, new development, brand spanking new building, and you say you have to fund reserves for very specific items. That's very different than a property that right now may already have issues, and we're asking them to borrow trouble by inviting other engineers in to take a look at what's going on. So we're definitely going to have an engineer on here in a bit, and we're going to talk more and more about that.
Well, that's the thing, if we're in that situation where we are having to raise capital, there are mechanisms to do that. Obviously, everyone's heard of the dreaded special assessment. No one wants to be special assessed, right? But it's the one remedy that we have that the board can do on its own. We have bank loans available, obviously, as well, but it's not a guarantee that every condo is going to qualify for a massive loan. That the banks are going to take into consideration several factors that some condos may or may not be able to satisfy, depending on the nature and consistency of their building and their finances, their rental levels, their current reserves, their collections. I mean, there's factors that could very well disqualify them from loans, leaving special assessment as the only option. Now, this was addressed in both bills, actually, I think wisely, and I hope when they come back around they include this. Some condo docs even have provisions that say a membership vote is required for a special assessment, which is insane. You elect a board to make responsible decisions for the community, including its finances.
Right.
And yet now you're going to hamstring them by saying, well, no, when you diagnose a critical issue and you need a special assessment to preserve the integrity of the building and everyone's safety, but then you're going to put it back to the membership who isn't going to have been privy to all the conversations with the engineer and all the site inspections. They probably haven't been to board meetings, but now we're going to ask them, sitting from their perch, to say, hey, approve a $1 million special assessment. Good idea, right? No, not a good idea. So both bills actually put in a specific clause that said boards will be able to take loans and pass special assessments regardless of what is in your documents, to give full control over the matter back to the board, which is the responsible informed party, which I thought was a great idea.
When you talk about gaining access to capital, what available options are there for a board in that context? Are you talking about individual unit owners going and getting lines of credit, or are you talking about the association as the borrower going and getting money?
Yes,
okay,
this is the
I'd like to
corporate
understand
entity
that.
of the association going and taking a loan in the association's name. They essentially pledge their assessment rights as collateral for the loan.
Okay, because they don't own anything, really.
No, I mean,
other than the fact that they collect a certain amount of money every month, every year. And that's how they fund it. Okay, did not know that.
No, that's right. And so the bank would essentially, if you default on your loan, step into the board's shoes and be able to lien and foreclose potentially on units in order to pay themselves back. So you pledge those assessment rights to the bank. You get your loan in the name of the association. You build the loan repayments into your budget over the next 3, 5, 7 years. And we fund the project that way, which is a perfectly legal way to do it. It's a great way to do it. I just caution boards that are out there listening, because it is not a given and guarantee that you will be eligible for a loan. And so the special assessment very well may be your only hope. Now, there was apparently talk, in the legislature about creating certain risk pools or some kind of other sources of capital for condos to do these projects, which I think is a wonderful concept if they can work it out. I'm an eternal optimist, Ted, but I have a little bit of pessimism regarding our state's ability to create a system, government run, that will really effectively deal with this problem and afford the proper funding to these condos. I mean, I'm not super optimistic that that's going to happen. I think that each condominium really has to help itself. I think they need to be financially responsible. I think they have to be informed. I think education is the key here, because we've got boards coming in to this building at all stages during the evolution of the building. And as I thought about this and how we can best address these issues, I mean, I think it really starts with an understanding of the evolution of the building itself. And I kind of broke it up into these 10-year chunks, and for good reason. I mean, we've got the initial 10 years essentially of the building being under what I would consider more of a developer responsibility period. And that tracks back to something called the statute of repose on construction defect.
Okay, now we're going to start talking like lawyers, everybody, so a little bit of warning here. So we'll, damn lawyers. All right, so we're going to talk about the statute of repose. Now tell me, law school contract, statute of repose. What are we talking about?
So without getting into the weeds, and to keep this as high level as possible, because this really is important information to try to soak up on some level, especially if you're a new condo. Bottom line is, if your developer messes up and doesn't construct your building properly, they very well may be liable for correcting the conditions in that building that should have been constructed correctly from the beginning, but there is an end date. I think most people have heard of the term statute of limitations, right? This applies to most things that we deal with, where there's some time frame outside of which we can no longer even bring legally a claim against the person that we've alleged has caused damage. Well, the same is true for developers. So when we say the statute of repose, it's this 10-year period whereby after that has run, dating back to the certificate of occupancies as issued by the local county officials, that developer is off the hook. They may have done the worst job in the world and either hit it really well or got really lucky, and the rebar doesn't start popping out of the building until year 10, day 1. That developer is off the hook. Okay.
Right, because I think the idea here is the difference between a statute of repose and statute of limitations is that the statute of limitations begins to run when you're aware that there has been defective construction.
Yes.
But what if you're not aware of the defective construction until year 15? The statute of repose says you didn't learn about it within the statute of repose, and so it doesn't matter when you discovered it. It's too late to go after the developer. Now, didn't one of these bills actually seek to shorten the statute of repose?
I know that was thrown around down to a 7-year period from the current 10-year period. Now, the logic behind that evades me. I have no idea. I don't know how to couch that any other way other than protection of the developer through developer lobbies. I understand the state wants to promote construction. We want to be friendly to business. I agree with all of these principles, but those principles have to be balanced with the principle of responsibility and accountability. And if I'm a developer, my job is to construct a safe, sound building. And if I don't, I have to be held accountable. And changing from 7 years to 10, I just don't see how that serves the public interest at all. And I would vehemently oppose, that. But what's kind of inherent in this conversation that boards have to be aware of is it's during this 10-year period, this is still a help yourself period, because no one is causing the developer to go back into the building and make sure that what they gave you is any good. The onus is on the board and the association to avail itself of the help available to diagnose these kind of issues. And that's engaging the engineers to come in, or architects to come in and do evaluations of our building that may seem like they're in perfectly good health. And this is where I think it's the mental component that boards, have to get over, because none of us want a problem. You and I, we sit here as human beings. We don't want to have cancer or diabetes, but
but not going to the doctor doesn't keep you from getting diabetes.
Exactly.
It just keeps you from knowing that you have diabetes.
Exactly. And so, and I have to encourage boards to think about their building like you think about yourself.
Well, I think that's a good segue. Let's, as we start to get to the conclusion here, I really want the listeners to have the benefit of your experience and your perspective. So let's come up with some things that we can tell them that are important for them to consider. And it is this idea, I'm going to start with one, and that is ignorance is not bliss. It is imperative that you own a piece of a building that, as you know it, is decaying every single day to some degree. And it's essential that you take care of it. And I also tell people, pick a holiday, if it's Memorial Day or if it's 4th of July or whatever it is. And every year on that day, I want you to get a camera, use your camera phone, and you need to record the condition of your property. If it's a single family residence, or whether it's that or whether it's a 10-story building, knowing what the condition is over time is a little bit like getting a chest x-ray every year so you can check to see if there's any changes. So that's my piece of practical to start out with. Dan, your turn. What do you got?
Couldn't agree more. And so, in this initial 10-year period, we need a full engineering inspection. I mean, and regardless of what you were given by the developer at turnover, it's not going to be sufficient for a number of reasons. I think you have to go through and hire a good professional to give you that diagnosis. And critical, so that's going to be out of the board's hands. That's going to be left to the professionals, the engineers. What the boards can do is establish good policies and procedures relative to the maintenance, the ongoing maintenance of the building. And that comes in the form of regular annual inspections, not necessarily by the engineer, but just by a traditional contractors that can come out. And like you said, with the painting, it's just a common kind of misconception that we can paint our building in year one and we don't have to look at it again until year 8 or 10, but that's simply not the case. So establishing good maintenance protocols from day one and keeping records of those maintenance protocols for the worst case scenario where, the association, and as you know as well as anyone, the first thing that insurance companies or developers are going to point to when we make a claim and ask for help is, that's not our problem, it's a you problem.
Right.
You, association, by failing to properly maintain what we gave you, exacerbated this situation or even created this situation, and so therefore you're culpable, not us. And if we don't have good, accurate records from pictures of the current conditions of the property, maintenance records to show that we do regular inspections of our roof, that we recaulk our windows on an annual basis, that we're looking for micro cracks or spider cracks in stucco and we're fixing those from time to time, your 8-year paint job simply is not going to be sufficient to carry you through the lifespan of that paint. And any credible painter is going to tell you the same thing, okay? And so we've got to have boards creating protocols that help themselves and presumably will keep our building healthy as well and prevent, the water intrusion that typically leads to the degradation of these components. But that water intrusion comes typically not from an actual construction defect, but rather a failure to maintain. So we can't pin everything back on developers because it's not always all their fault.
Right.
Oftentimes it is, in fact, our inadequate maintenance of a building or laziness that creates the problem. And associations have to own that fact.
Well, because you have these buildings where my experience in the property insurance world is Hurricane Irma impacts the building, no doubt about it. You can see the damage. It's palpable. It can be documented. But then they discover that there was defective construction that made the building especially vulnerable to a wind event. Then in addition to that, we have a poorly maintained, poorly documented building. And that is plenty of opportunity for an insurance company to look to pass the responsibility off back to the owners and to deny the claims. The other issue is that the insurance companies do such a poor job of assessing the impact of storms on things like windows and doors. An engineer told me recently, people forget that you can have damage to a roof from a storm, even if it doesn't leak. It means that the insurance companies are going to look at the condition of these properties over time. And if they can see some degree of degradation over time leading up to the storm event, again, lots of opportunity for them to tell insureds that they're going to limit or deny the benefits the policies provide.
Right, and you know firsthand how demoralizing that battle is for a board when it is fighting with its own insurance company that presumably is there to protect them and that they've paid in for years and years of premiums that never went touched or implicated at all. And then the one time we need them, right?
Right.
And we get what often we get, from those kind. Not to say that they're all bad, and not to say this happens all the time, but we see it too often to be able to comfortably rely on the fact that insurance is going to help us. And in some of these cases, it's simply not an insurable event. I mean, the slow degradation of our building through lack of maintenance is not an insurable loss. Right. So it's a many-sided, many-faceted approach that we have to be considering, and it again gets me back to this educational component. I cannot sit here in good faith and tell you that a volunteer board member should be thinking of any of this. They shouldn't. So the way that the both statutes, proposed statutes, address this also was making mandatory for all new board members to attend an actual board certification class. So currently in the statutes, board members have two options. They can either attend a class and get certified, or they can simply sign a piece of paper that says, I've read my association governing documents and agree to uphold them. Okay, that doesn't get us very far.
I don't know. Right. Let me ask you this question that I have gotten about what happened at the Champlain Towers South building. What about the issue of individual liability for the board members who may have, and we're speaking hypothetically about the board, at Champlain in the Surfside condo collapse, but everybody kind of wants to know, if I have a unit that I own in a building where the individuals on the board knowingly ignored it, what is the liability of the individual of the board members?
Well, it may very well exist in that scenario. So, the individual directors are covered by directors and officers insurance policies, your D&O coverage or E&O coverage.
Right. And again, good luck with that.
Well, it's a different issue, right?
Right.
So now I'm a board member and I think, well, why am I crazy enough to sign up for this position in the first place? And then hopefully secondarily, they're asking themselves, what am I exposing myself to with respect to potential liability? And typically the answer is, no, don't worry about that. You're covered. You've got your directors and officers policy. So, if something goes wrong or you make a bad decision and you all get sued personally, that they can't come after your assets. The insurance will cover you, defend that case, pay out, et cetera, so that we encourage people to volunteer for the board, and and that they're not worried about this potential personal liability. Well, that all goes away when we've got a board that knowingly or grossly negligently does not carry out their fiduciary duty to the corporation. And this can come in a variety of ways, and the standard's fairly high. But theoretically, right, if we've got known and obvious hazards or problems around our building, and we've been told by professionals that we have issues in our building, and we do nothing to act on it, for whatever reason that is, whether it's financial or otherwise, we were busy dealing with emotional support animals, that is when potentially an individual director may actually be liable for a breach of their fiduciary duty to the corporation because they did not act reasonably. They presumably did not act in good faith in carrying out their duties because they are the responsible party for that entire building, and no other homeowner can sign a contract with an engineer or with a remediation company or any other party to actually fix the building. They have to rely on the board as the executive body of that corporation to make decisions in the best interest of the corporation and its members.
Right. I think it's this idea that if you are a member of a board, these have got to be things that are rolling around in your head. They have to be. And what I would invite you to do is to have a conversation as a community about these specific issues. Let's not be afraid to talk about the liability piece of it. I will tell you that a lot of the errors and omissions policies are written in such a way that the only time they will cover you if you are sued as an individual unit owner is if on the same day the owner of the building his cat gets run over by an airplane. The things that have to happen sometimes to trigger that coverage, if you can even get it. And a lot of the brand name insurance companies have gotten out of the condo business. They don't want to be involved in it. And there's so many people that are sued over silly reasons because of choices they've made as board members. It makes it really difficult. But I think people have to maybe rise to the challenge. And it is this idea that understand you don't live in a single family residence. You live in a community, and the community's decisions are made by the individuals that you elect. And if they don't do what they're supposed to do, you need to understand what resources you have available. And that might be making sure that they have an errors and omissions policy to cover those kinds of things. Or it might simply be voting on a protocol. Let's just decide right now what we're going to do over the next 5 years. And that means that every year for the next 5 years, we're going to engage certain professionals who are going to come in and give us opinions and give us a sense of when our capital pieces, like the roof, the paint, or the pavement, when they are going to end their usable life, and start planning for that. I think a lot of people move into condos thinking that this is the last home I'll ever own, and I'm going to be able to have the greatest control over how I spend my money. And in fact, it's the almost opposite of that you are now giving over to other individuals who, by the way, you should show respect to because they do work very, very hard. I go to these meetings, and I'm sure you're at tons of them, where just some communities have this visceral reaction. Like the second the meeting opens up, it's just game on. And people are screaming and yelling and accusing each other of just horrible, horrible things.
Well, I'm glad you brought that up too, because honestly, I think this is one of the issues that detracts from the board's ability to address these more fundamental high-level problems, because when they are bogged down with dealing with the post on next door and all these minutia issues that keep coming up and the personalities that keep coming up, and when these boards feel like they're getting railroaded at meetings, and it's just they don't even want to do business anymore. Like, that is not an environment in which good business decisions are going to be made.
Right.
And so I think that respect factor is key. As an owner within a condominium, you have every right to address your board, question your board, make suggestions to your board. You should be
involved. You should go to the meetings, listen to what's going on, take care of your investment.
That is right. But at the end of the day, we have to respect the board and allow them to do their job. We have to agree to disagree. We have to bring some measure of civility back to our own communities, and it's kind of the beautiful thing about what we're doing here with condos, and why I like my job is it's this self-contained universe. It's this quasi-governmental entity that really decides its own fate. It gives us the opportunity to act in a manner that we wish our government officials would act, or our state or our country would act. We have all the power vested in 50 people, 100 people, 500 people. We're a microcosm of society, and we can do better. The possibility exists. The problem that I've seen, unfortunately, is that humans are humans, and the personalities and the emotions and all of that oftentimes clouds the bigger picture, detracts from the board's ability to address the bigger issues, and I see a lot of boards just get demoralized.
Right, right.
Essentially give up. I mean, they're just getting badgered and
Understandably.
hammered.
And it's not even just what happens at the meetings. I've spoken with board members that have told me they don't even want to walk to their car because people will just roll up on them and confront them about how dare you assess me for anything, as if it's a personal affront.
But that's why we need these statutes.
We need direction.
We have to have it. We do. As much as I love the concept of self-governance and self-determination, and that is applicable in many of the things that we do, on some level to alleviate the issues that we just addressed, the boards have to be able to tie their decisions back to a higher authority, to look to the experts, the folks that are paid, and in some cases well paid, to tell our volunteer boards, here's what you need to do for the benefit of your community. Follow this guideline, and we can almost assure you of success here, and nothing's perfect, and that's okay. But we'll accept that risk when we're undertaking the types of activities that are calculated to lead to a good result. And so this legislation is just absolutely critical to provide that framework to our boards so that they can point somewhere. When their members start complaining and the financial concerns come up, the boards have to be able at some point to say, this is out of our hands. This is mandated. We have to do it. We should be doing it, so we're going to do it.
I want to take a second to thank Dan Greenberg for taking time out of his practice to come in and sit with us to address some of these issues. As we've mentioned before, this is an issue that is associated with my practice, in that my practice focuses on the representation of these kinds of large developments when they are dealing with some of the more common problems associated with those buildings, especially in Florida. We have a lot of hurricanes, we have a lot of sinkholes, and the water and the sea salt that hits these buildings can do enormous damage to the building, to the point where you can develop these kinds of structural issues. We're going to continue to report on these particular issues and share additional media about them. If you have specific questions that you believe we may be able to assist you with, I would invite you to go to my website at Corliss Law Group, or to look up Dan Greenberg, who provides fantastic services in the area of condominium representation. I wish you the very best. Thank you. Ted Corliss here at the Corliss Law Group.